Okay, this is one of my favorite lectures to give because it's so important for you guys to understand, the civil liberties that you have. These are found in Amendments 1 through 10 of the Constitution, and these are your protections against government action. So this picture here, I chose it because, the pandemic brought individual religious liberty and community safety into sharp conflict. So when we talk about rights and civil liberties, your civil liberties are not unrestricted. If there's a right, there's usually a corresponding duty. So during the pandemic, we actually saw a lot of churches, you know, sue the government based on the mandatory closing because you have a First Amendment right to exercise your freedom of religion. But then you also had, these COVID lockdowns. So it's a good example of the balance between, rights and duties. So we're going to talk about civil liberties and civil rights this week. So these are not interchangeable. These actually are distinct. A civil liberty are limitations of government power that are designed to protect freedoms, such as, the right to freedom of speech, the right to bear arms, things like that. Civil rights are constitutional guarantees that the government will treat people equally, regardless of whether they belong to a protected class. These protected classes are race, gender, ethnic origin, religion, in some cases age, and I think the coming civil rights cases are going to be based on gender identity. So remember when we talked about the formation of the Constitution, one of the things that was important was the Bill of Rights. So the Bill of Rights was created in 1789 and ratified in 1791. So there was a debate over the protection of civil liberties and the inclusion of the Bill of Rights. It was a major impediment to ratification of the Constitution because, they were trying to get away from England and the things that the king did. England had their own Bill of Rights, and they were trying to, have these protections for the individuals so that, we didn't end up with a tyrannical government. So the issue that we had in ratifying the Constitution was that the requisite number of states, would not ratify until, we had these amendments to protect civil liberties. So here's some that are not contained in the amendments, but they're also important. Article 1, Section 9 of the Constitution, prohibits Congress from making these types of laws. So you can't have what's called a bill of attainder. So that's a law that punishes or convicts a person for a crime without a trial. In our country, we have a right to a trial, and to confront our accusers, which we'll discuss further on in this lecture. We can't have an ex post facto law. So that's a law that takes effect retroactively. What if the police walked into class one day and said, hey, you have a blue laptop. You're going to go, or I don't know, I'm trying to give examples, or, look at marijuana, right? Marijuana is legal in California. What if they made it illegal again? And then said, hey, well, you had a marijuana card from this state to this state. So, we're going to take you to jail. We can't do that. But then we cannot suspend the writ of habeas corpus. There is an exception here for public safety in cases of rebellion or invasion. That's where the Patriot Act gets involved. But the writ of habeas corpus requires a hearing by a neutral judge to determine whether a person has been unlawfully detained. You see writs of habeas corpus a lot in civil detainment. You see it also in death penalty cases. Once they've reached their state appellate rights, they have federal habeas. So what are these amendments? So I'm going to tell you that one of the biggest things I want you to be able to take out of this class, and I apologize for the dogs, they're a little nuts because of the weather. Amendments to the Bill of Rights. Know your amendments. These are your protections against the government. So the First Amendment, there's multiple prongs to the First Amendment. That's the right to freedom of religion and speech, the right to assemble, and to petition the government for redress of grievances. So you have a right. We have a right if we're upset with the government to say, hey, fix it. The Second Amendment, that is the right to keep and bear arms. That is, our right to maintain gun ownership. Now, the Third Amendment, a lot of people don't know, and that's okay. And that's because we haven't had it happen. Remember, the Constitution was written, back when they didn't have formal Navy bases, former Air Force bases like we have now, right? So the Third Amendment says that the government cannot house soldiers in your home during war. The Fourth Amendment, this is one that, the Fourth, Fifth, and Sixth kind of are your criminal law related amendments. So the Fourth Amendment protects you from unreasonable searches and seizures and says any warrant issued by the government must be issued by probable cause. That's important. That means the government can't just come into your house and look for contraband. The Fifth Amendment includes due process and indictment by grand jury for capital crimes, as well as the right to not testify against yourself. You have that protection against self-incrimination. This due process is important to differentiate between 14th Amendment due process, because this only applies at the federal level. The Sixth Amendment is your right to a speedy trial by an impartial jury. You also have a right to counsel under the Sixth Amendment and the right to a public trial. The Seventh Amendment says we have a right to a jury trial in civil cases. So a civil case is not going to be a criminal case. What it's going to be is, like a personal injury, a car accident, or if you're suing somebody you do have a right to a jury there. The Eighth Amendment says you can't have excessive bail, excessive fines, or cruel and unusual punishment. That's where you're going to see a lot of death penalty litigation. The Ninth Amendment, it says that all rights are retained by the people, even if they're not listed specifically in the Constitution. We own these rights. And then the 10th Amendment says that all powers not specifically given to the federal government are retained by the states. That's the important thing in our Constitution, that we have states' rights. So in this lecture, we're going to actually go through a lot of these protections in further detail. So this idea of incorporation relies on the due process clause of the 14th Amendment. So initially, all of these rights contained in the Bill of Rights only pertain to government action at the federal level. So take the right to unreasonable searches and seizures. The FBI, was, constrained by the Fourth Amendment, but your local police force wasn't. So it didn't really make sense. So after the 14th Amendment was ratified in the Civil War, the Supreme Court expanded the protections of the Bill of Rights to cover state government action. That is known as incorporation. That's something that's very important for you to know. This is a nice chart that kind of shows where some of these protections fall. Your criminal protections here are the 5th and 6th. I'd say the 4th is up there as well. Individual freedoms, you're dealing with the 1st, 7th, and 8th Amendments, also as a criminal one. So this is just an interesting chart. So let's talk about the First Amendment. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. So that's a lot. Let's break it down. So there's the Establishment Clause for religion. That prohibits the government from exercising a state religion or from favoring one religion over another. The Free Exercise Clause. That prohibits the government from preventing or controlling religious practices. The Free Speech Clause. That prohibits the government from suppressing or restricting most forms of speech and symbolic speech. The Free Press Clause. That prohibits the government from restricting the rights of the press to disseminate news and express opinions. The Free Assembly Clause prohibits the government from restricting peaceable assemblies. And then the Right to Petition Clause permits individuals or groups to petition the government, including writing and calling elected representatives. That's an important aspect of civic engagement. Lobbying government officials, which we'll talk about when we learn about the Congress, and filing lawsuits within the courts. So we have all these rights under the First Amendment. So what is freedom of expression? That deals with a lot of these rights protected under the First Amendment. So with speech. So what is speech, right? Speech includes written communication, including the internet, as well as symbolic speech and non-communicative speech. So symbolic speech would be wearing a black band around your arm, flag burning, and burning the American flag. It would be, turning your back, right? Non-communicative would be turning your back. So freedom of expression also protects types of expression that many or most people find offensive, such as hate speech. Just because it's not nice doesn't mean it's illegal. So one of the most recent cases related to the free exercise clause, and there's actually going to be a video I will post about this, is a Masterpiece Cake Shop versus the Colorado Civil Rights Commission. So in this case, a lesbian couple wanted a wedding cake, and the owner was a Christian man and said, "No, I will not make a wedding cake for a lesbian couple." He said, "I will make, you can have any other cake you want, just not a wedding cake, so it's against my religion." And in Colorado, there was a civil rights law that prohibited that from happening. So the case appealed this way all the way up to the U.S. Supreme Court, where they did rule in favor of the cake baker. What's interesting to note is now that this case is gone, the Satanic Temple has approached the man wanting a satanic cake, which again, he said, "No, that's against my religious beliefs." And the case is working its way back up to the Supreme Court, trying to see where it falls. Then we have the Second Amendment. Hold on, let me step back a second. When we talk about speech, I also want you to think that a lot of this comes up. I really think that you guys should reflect upon, the issues going on with President Trump. Whether the speech, what comes down to a lot of these indictments is going to be whether speech is protected or not. If his speech is protected, then we're prosecuting someone for exercising their First Amendment rights. I really encourage you guys for your paper to research this. We may do some more with that. So the Second Amendment, a well-regulated militia is being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. So the Second Amendment was a little controversial for the Civil War. That's because the presence of slaves. Many states did introduce laws to prohibit slaves from carrying firearms. So then in the 1930s, we saw laws restricting ownership and sale of certain types of firearms. And these have fueled the debate over whether the Second Amendment says we have a right to organize the militia or the individual right to bear arms. So the way the courts are ruling is that we have that individual right. Most recently, there was a case out of New York, the New York gun law case, which dealt with concealed carry permits. In that case, the Supreme Court ruled that concealed carry permits, that's under the Second Amendment, you have a right. Now, what that means is, as a government, the sheriff's department or whoever regulates it in that jurisdiction can, require you to qualify with the gun. They can have you register the gun. They can do a background check on you, but they can't require you to show cause as to why you need the gun, which is what the law used to say. So in 2008, the Supreme Court found an individual right to bear arms for traditionally lawful purposes, such as self-defense within the home. That's falls within the Second Amendment. So then in 2010, the Supreme Court incorporated the right to bear arms into that due process clause, ruling state laws regulating firearms could violate that constitutional right. This is the Second Amendment, that's one of those ones that there's constant litigation on. That's because it is controversial. I think back to Texas, when there was some Black Lives Matter protests back in Texas, I remember seeing all these people carrying guns because Texas is an open carry state. We're one of the few states that is not a constitutional carry state here in California. So the Third Amendment, that prevents the federal government from ordering soldiers in the home of any person without consent during peacetime or war in a manner not authorized by law. We don't really have to worry about that, okay? So there's a reason why this one has not been incorporated to the states, because the military, fighting a war is a federal act. We don't have to worry about the state. Yes, there's an argument that maybe the National Guard, they could apply to them, but if they are fighting a war, they would probably fall under, the federal military. So this was important to the framers of the Constitution because of the Quartering Acts, which required colonists to house British troops in their homes. Think how odd it would be if an invading force, you're forced to share your room with a Russian soldier or something like that. It'd just be craziness. Then we have the Fourth Amendment. The rights of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the places to be searched and the persons or things to be seized. So there's a lot in this. So this is basically the idea that your home is your castle and you should be protected in it. So, searches have to be with warrants unless they fall under warrant exceptions, which your book does discuss some of them. They got to have probable cause, meaning that a police officer can articulate to a court, why we need to search the place, what do we expect to find, and how was it used in a crime. So there's issues with equitable applications of this, right? Because they have to apply for and receive a search warrant prior to a search or seizure. But there's exceptions. So like cars, cell phones, the way I look at it is if you can take it and book it into evidence, you have time to get a warrant. But a car is something that's movable. If you don't have reason to seize the car, right, then you have to search it without a warrant. And that does happen. That is an unlawful exception. Police can search or seize property without a warrant if there's consent. And then if there's exigent circumstances, so exigent circumstances are things like destruction of evidence, a hot pursuit, meaning they're chasing a bad guy. If police are chasing a bad guy and he runs into a house, they can chase after him. Or, they hear someone screaming and they need to get in. Another one is plain view. If a police officer pulls you over and you keep your methamphetamine and your gun on your passenger seat or in your back seat, and he looks in the car and sees it, that's an okay search or and seizure. So, your book talks about no-knock warrants. So no-knock warrants are high-risk warrants that are done typically, in the evenings to prevent, bad guys from fighting with law enforcement. So, your book argues these warrants cause confusion and people might think they're being burglarized, and they look at the killing of Breonna Taylor for that. That was a no-knock warrant. Okay, then we have the Fifth Amendment. This is a long one as well. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject to the same offense to be put twice in jeopardy of life or limb, nor shall they be compelled in any criminal case to be a witness against themselves, nor be deprived of life, liberty, or property without due process or law, nor shall private property be taken for public use without just compensation. Wow, that's a lot. Okay, so we're going to look here. This says that we can't, if we're going to charge you with a crime, it has to be under presentment or indictment of a grand jury, unless you're in the military. If you're in the military justice system deals with you. So grand jury is more of a federal way. When we talk about the judiciary, we'll talk about how states can prosecute people. So you have a right against double jeopardy. Jeopardy attaches at certain times, and once that jeopardy attaches, we can't try you for the same crime twice. We can't force you to testify against yourself. You can't be deprived of life, liberty, or property without due process. And then just compensation, which is eminent domain, where the government takes private property for public use. So there's a lot in the Fifth Amendment. So, this breaks it down more. The right to an indictment by a grand jury in a felony case, protection against double jeopardy. This does not prevent a subsequent civil trial. When I think of that, I think of O.J. Simpson, right? O.J. Simpson was found not guilty for murdering his wife and her lover, but he was found civilly liable for the wrongful death. The right against self-incrimination extends to persons in custody. So for your Miranda rights, a lot of people think if you're being arrested, you must be read your Miranda rights. That's actually not true. If you are in custody and they want to interrogate you, then you have to be read your Miranda rights. So booking information, such as all the basic, your basic name, date of birth, stuff like that, that is not something they have to Mirandize you for. And then you have the right to due process. And then it talks about eminent domain. So, or civil forfeiture. Sometimes law enforcement will engage in asset forfeiture in the event that there is assets to be taken. Usually it's due to drug issues. Okay, so the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime has been committed, and which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and have assistance of counsel. A lot. So let's start. You have a right to a speedy and public trial. In Riverside County, that has actually been a way where a lot of cases get dismissed because we don't have a lot of courtrooms. So I'm not giving legal advice, but if you were facing a crime, a lot of inmates could actually roll the dice and say, I'll take it to trial. And in the event they don't have a courtroom that day and you don't waive your right to a speedy trial, you have your case dismissed. And they can only refile once. So it's important. Public trial. Now, that doesn't mean necessarily that TV cameras have to be in there. It just means that any one of us can actually go over to Southwest Justice Center over here and sit in on a trial. You know, you have to have an impartial jury. That's where the voir dire section of jury selection comes in, where they start asking questions to make sure that the jury is not biased on either way. Yeah, it doesn't mean a jury of your peers does not mean it has to be a jury of people like you. It's just a cross section of the community. You have the right to know the nature and cause of the accusation. This goes into this process called discovery, where your defense attorney gets police reports and any information about what they're using to prosecute you. It's part of our rights. They have to know. Because think about it, you have the weight of the state coming to prosecute you for a crime, and you may not have, the ability to fight the state. And then you have the right to confront your witnesses. That is, you have a right to know who's being used, and you have the right to cross-examine them. You have a right to get witnesses to testify for you, and you have the right to the assistance of counsel. So there's a lot in there. I chose this to leave this in because this is Clarence Gideon. Gideon versus Wainwright is an important case. There's an interesting movie on YouTube called Gideon's Trumpet about his case. So this gentleman, the right to counsel is something that's evolved over the years. First, it was the right to counsel in death penalty cases. Then it was serious felonies. Then it was felonies. And it was misdemeanors. And now it's, pretty much everything except traffic court. You don't get a public defender for that. So Mr. Gideon, he was convicted of burglarizing a Florida pool house. He was sentenced to prison, and he filed his own appeal up to the U.S. Supreme Court for violations of his Sixth Amendment right to counsel because he was forced to defend himself. And that case, Gideon versus Wainwright, is one of the most important cases in our system. It helped create the modern public defender's office. So here's a breakdown of everything that I had mentioned. Only thing I didn't really mention was, you have a jury from the state where the alleged offense occurred. Again, looking at the indictments against President Trump, I think it's going to be kind of interesting because you have juries from all over the country. Florida for the Mar-a-Lago, we have DC for the tweets, we have Georgia and New York. So that's going to be interesting because, we have to see, where exactly where was he when the offenses occurred based on that, such as the Georgia case. Was he in Georgia during the tweets or what? So then we have the Seventh and Eighth Amendments. The Seventh Amendment, like I said, deals with civil, non-criminal litigation. You do have a right to a jury trial. That is something that has been kind of always under fire in Riverside County. We have that beautiful historic courthouse in downtown Riverside for civil cases. And, for a time, it was actually being used for criminal cases because we had so many criminal cases on a backlog. So then we have the Eighth Amendment. The Eighth Amendment states that excessive bail shall not be required, no excessive fines imposed, and no cruel and unusual punishment. But bail, and that's why I wish we were in the classroom, because bail is an interesting concept because we have these uniform bail laws. So like for a DUI, it's $2,500. So you got to put up 10%. That's like what, $250? Well, paying that for me, may be different than you, right? When does that become excessive? Should it be something that's looked at on an individual basis, or is it something in general? We have the generalized bail schedule in California to promote, fairness, right? Everyone who does the same thing gets the same bail. Maybe that's not fair. I don't know. So then the Eighth Amendment, prohibition against cruel and unusual punishment has been controversial with regard to capital punishment. When I say capital punishment, I mean death penalty. So the Ninth Amendment, kind of fun. It's a lot of interesting legal language. The enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What the heck does that mean? There's been different interpretation. So some interpret the Ninth Amendment to protect certain natural or common law rights not enshrined in the Constitution. Other judges and scholars view the amendment as merely a tool of constitutional interpretation. So then we have the 10th Amendment. So the 10th Amendment states, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So the 10th Amendment was actually what was used in the Dobbs healthcare decision about overturning Roe versus Wade. It's a tool of constitutional interpretation that restates the power of the federal government as those enumerated or implied in the Constitution. All other powers reserved to the state. So the way the court ruled in Dobbs was that, there's no actual, the Constitution does not say you have a right to an abortion, which is why they left that to the states, because it's expressly enumerated. So going back on Dobbs, I just think it's important, wherever you stand, we're not here to discuss ideologically where we stand on, the abortion issue. It's important to understand, though, what the court decided. So this idea of the right to privacy, you guys had to read the Constitution for your homework. It's not in there. You can find it. I'll give you extra credit, but it's not in there. There's still provisions that, over the years, the interpretation has been that maybe we have a right to privacy. Thinking about you can keep a gun in your house. We don't want to force you to house people. You have a right, protection against unreasonable searches and seizures. You have due process in the takings clause. So they're trying to say that, if you really look at it, there's an implied right to privacy. So, take that for, what it is. It's not something that's been actually given. That's actually been decided for us through case law. Okay. All right. If you have any questions, please reach out to me.